shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
It's 22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record?
Thank you, Mr. Clerk. Good morning, Your Honor. Hank Brennan, on behalf of the Commonwealth, along with me, Attorney Adam Lally, and also Attorney Laura Flo.
Good morning, Mr. Brennan. Good morning, Mr. Lally. Good morning, Ms. McCarty.
Good morning, Your Honor. Elizabeth Little appearing on behalf of Defendant Karen Reed.
Good morning, Ms. Little.
And good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti. Good morning, Ms. Reed. All right.
Also, thank you. Mr. Jackson appears to be in Zoom.
Okay, we can't see him though, Jim.
Okay. We can't see you. Is that okay?
That's correct. All right. Good morning, Mr. Jackson.
It's really nice to know that the entire defense team is there. I'm not sure Martin Weinberg is there. I don't believe I saw him. But it's nice that David Unetti, Elizabeth Little, and Alan Jackson is there via Zoom.
All right. We have several motions this morning. Let's start with motion for admission pro hac vice that you filed. And Mr. Unetti, I know these are freely granted, but I have a question about here. So you say good cause exists to grant this motion because Mr. Alessi has specialized skill and knowledge in representing defendants in matters of this nature. What do you mean?
Mr. Alessi is somebody with decades of experience in the courtroom, both on an appellate level and on a trial level. He has handled many criminal cases over his career. I have actually consulted with him on a criminal matter. I know of no better trial attorney in the country than Robert Alessi. There are aspects of our defense that would greatly benefit from his expertise. I'd rather not go into the specifics in terms of the division of labor on our team, but I'd ask the court to, take judicial notice that with his background, with his experience, he is going to add value to this team and protect my client's constitutional rights.
Okay, so he's not a criminal lawyer, but he's a lawyer who does some criminal work. I just don't understand what you mean by representing defendants in matters of this nature.
It's clear that Judge Bev doesn't like that statement, representing defendants in matters of this nature, right? Because to Judge Bev and to Michael Morrissey, whom I believe is her friend and she's helping, she's doing the dirty deeds on behalf of Michael Morrissey, she doesn't care about Karen Reed. Judge Beverly Cannoni has proven since day one that she does not care about Karen Reed. She doesn't care if Karen Reed gets hit by a bus. She doesn't care anything about Karen Reed. She doesn't care what happens to Karen Reed as she puts her finger on the direction of Karen Reed's fate. The power that Judge Bev has over Karen Reed's life. She's proven she doesn't care. And so to me, Judge Bev is bothered by the wording in that statement. Defendants who are being prosecuted in matters of this nature. Judge Bev wants to get down to the bottom of what the defense team is implying by matters of this nature. So that what? So that she can correct them, right? We all know that Judge Bev thinks Karen Reed is shit, right? And I'm not even convinced that Judge Bev thinks Karen Reed is guilty. I think Judge Bev is just following orders from on high. Michael Morrissey.
He has represented criminal defendants throughout his career.
Okay. All right. Thank you. All right. So let's go on to the discovery motions. We'll start with...
It's like... David Unetti's sighs. It's like because he didn't say anything to Judge Bev to trigger her. And I feel like the defense team has had to tiptoe around her bullshit. How tragic, too, to be a defense team and to have a judge as nasty and horrible as Judge Bev, and to have to learn that you can't actually speak your mind to this judge. You can't even speak reasonably to this judge. You have to tell this judge what she wants to hear. So if this judge is prying for clarification on one of your statements, you better be cautious and respond cautiously or she will eat you alive. And to me, David Unetti did a good job.
The requested records of Mr. Reed. I'll hear you, Mr. Brennan.
The Commonwealth has filed a Rule 17 motion to obtain phone records from William Reed for a 24-hour period. Secondly, the Commonwealth in that motion is looking for records regarding call logs for a 30-day period for William Reed. Although a different motion similarly, the Commonwealth has filed motions simply for the call log for 30 days for Janet Reed.
As Karen Reed's parents sit right there, you can see them to the right of Prosecutor Brennan. Karen Reed's mother is wearing like a dark pink shirt, and her father is wearing a navy blue suit. Like, just to think about what is going through their minds right now, right? Like, that this has all happened to their daughter. The entire state went against their daughter for something she did not do. And now the state wants to confiscate their cell phones, even though their daughter didn't do a damn thing.
Commonwealth has a burden with two of these charges, one being second-degree murder, to show the element of knowledge. It is the government's burden to show that Miss Reed knew she struck John O'Keefe. Second-degree murder, as the court is aware, is a person committing an intentional act with a...
If you guys rewind a little, you'll see Aiden Kearney's head shake. He's right behind Brennan. You can see him in a white, I believe he's wearing like a white blazer or a white suit. I'm not sure. But he's sitting in the row behind Karen Reed's parents, but it looks like he's sitting right next to Karen Reed's father. Anyway, just a few seconds ago, Aiden Kearney shook his head. It's just great.
Strong, plain likelihood of death. In a second-degree murder charge, there are a number of different theories that a Commonwealth can progress. It could be an intention to hit somebody, or it could be that somebody intentionally drove, struck somebody, left them behind, and didn't render aid knowing that there's a strong potential likelihood of death. When Miss Reed knew that she struck John O'Keefe is a critical issue in this case.
I'm sorry, I'm distracted by Aiden Kearney. Aiden just let out a big sigh. It's great.
Simply because the government has significant evidence outside of phone records to support and to convince that Miss Reed knew she hit John O'Keefe when she did, the government's entitled to their full value of their proof. The records for 30 days begin with that aspect of William Reed's records. Miss Reed calls her father and her mother a little after 1 o'clock on the night she struck and killed John O'Keefe. She called both of them, and those calls were unanswered, according to the phone records.
So, this is supposed to be a commentary video about the hearing today, but I can't help but notice Aiden. Aiden just looked at the female next to him. I forget her name. Believe is his girlfriend. But he just looked at her when Brennan said that Karen Reed made a phone call to her father after 1 a.m. on January 29. And that's not true according to the record, according to the data that we know. And I think Aiden Kearney is responding to that statement in kind. He is shaking his head and looking to the person at his left and like shaking his head like that didn't happen.
The inference that a 40-something-year-old woman is calling her parents at 1:30 in the morning after this tumultuous event. The inference is strong evidence that Miss Reed knew she had done something terrible. She knew she had struck John O'Keefe, and she knew that she had left him behind. The 30-day period is an attempt to protect the privacy rights of William and Janet Reed by not asking for the call, the text messages, not asking for SMS messages, not looking to forensically download the phone, just the call records, because I expect it will establish that there are no other calls in that 30-day period from Miss Reed to her parents at 1:30 in the morning.
But can't you get that from Ms. Reed's phone?
No.
Elizabeth Little just nodded her head, like, yes, you can get it from Karen Reed's phone. And guess who still has Karen Reed's phone? Guess who still has Karen Reed's phone? It's not in Karen Reed's possession. This is like a waste of time. And guys, what are the call logs going to reveal? They're going to reveal the phone numbers that were dialed. They're going to reveal the duration of the phone calls. They are not going to reveal the context of the phone calls, right? Like, they didn't do this for Jennifer McCabe. They didn't do this for Brian Higgins. They didn't do this for Brian Albert. They didn't do this for Nicole Albert. They didn't do this for Matt McCabe. Notice how they want to obsess over Karen Reed's phone, but they don't want to obsess over all of the phones of all of the people who were at 34 Fairview that night.
There were 2 search warrants for Miss Reed's phone.
I can't read them. The search warrant that was attached that I have isn't clear, so I'll need clear copies of those search warrants.
Those are provided by the defense. I can provide clear copies. The 2 search warrants for Miss Reed's phone are from a period of January 28, 6 p.m. to January 29th at 6 p.m.
Okay.
And the other one is January 28, 9:30 to January 29th, 5:30.
Okay.
And so they're not in Miss Reed's records. I am not looking to see any of the other numbers that the family called, friends, family, whatever their purpose is. I'm not looking to even see it. I want to see and demonstrate there's an absence of phone calls between Miss Reed and her parents the 30 days prior to when she drove into John O'Keefe. Now, it would help the defense. They want to expand that to 6 months or a year. I'm agreeable.
I also don't like, I get it that it's the prosecution and the prosecution wants their narrative to prevail, to rule the day. But the fact that he keeps stating what happened as if it was a fact, as if Karen Reed really drove and hit her boyfriend, despite the testimony from people who were hired by the federal government, right? The prosecution to this day does not give a damn that the federal government exonerated Karen Reed with their actual accident investigations, with their actual accident reconstructions, with their actual engineers, their PhDs. The federal government has more resources than the state government. That's how it's always been. The federal government will always have more power and more resources than any state government. And with their resources, the federal government proved that Karen Reed did not hit John O'Keefe. But look at the fucking prosecution, how they continue, how they persist that it happened as if it was a fact.
Because if there was phone calls at 1:30 in the morning, I would not argue the inference that it was remarkable. That would be an unfair inference. But in the absence of any other calls, it is terribly remarkable that she is panic calling her parents at 1:30 in the morning. And here's why it's important. The type of injury John O'Keefe suffered that led to his death was a type of injury that was treatable. If he had received treatment within 1 to 2 hours, I expect that there are medical procedures that could have saved him. They could have produced a drill and drilled it into his brain.
I would object to this attorney testifying as if he's a medical expert. Like, I would have stood up if I were Elizabeth Little or David Unetti or even Alan Jackson on Zoom. I would have objected to the attorney providing testimony as if he's a medical expert in this. At the same time, I have said in previous videos that anybody inside 34 Fairview could have saved John O'Keefe's life. They made sure he would not survive, proven by that 2:27 a.m. search all the more, as well as their behavior with the Ford Edge, their behavior with Brian Higgins driving around at night even though he was intoxicated, their behavior with not having anybody else's alcohol level tested but Karen Reed's, right? Like, so much bullshit happened, right? Because it was a cover-up. When at any point anyone in that household could have saved John O'Keefe's life. They did not want him to survive his wounds because they didn't want the chance that John O'Keefe would tell the authorities who did this to him. It was a murder. Some people think it was an accident turned homicide. And again, we will never know. It could have been a murder from the beginning. We will never know. But the fact is that he was murdered. The fact is that he was murdered because nobody in the house did a damn thing about his wounds. And they waited on purpose. They put him outside on purpose. They searched how long it would take for him to die in the cold on purpose. So, though Brennan is of the prosecution, which means he's already full of shit, and he continues with the narrative that Karen Reed did this, further proving that he's already full of shit. But in his statement, he has a point that, yes, anybody at 34 Fairview could have saved John O'Keefe's life. And instead of questioning all of those individuals, investigating all of those individuals, while Karen Reed was at home at One Meadows at John O'Keefe's house at 12:36 a.m. 12:36 a.m. Karen Reed was at One Meadows. But sure thing, Brennan, just completely overlook that and keep targeting Karen Reed for something that the McCabe's and the Alberts and Higgins had power to mitigate. They could have mitigated John O'Keefe's wounds. They could have mitigated the fate of his life, his ability to live the next day. And as I've said in previous videos, he may have been impaired. He may have had a disability because of his wounds, because of his brain injuries. Maybe. Or maybe he would have recovered fully, guys. We don't know. And I said in previous videos, there have been people who have survived worse things than John O'Keefe went through. What ultimately killed him was the cold. Again, I have followed lots of court cases. I've watched countless documentaries. I've read countless stories. There are people who survived far worse wounds than John O'Keefe had. John O'Keefe could have survived his wounds. But it's not Karen Reed's fault that he didn't.
To create bleeding so it wouldn't swell, or they could have cracked his cranium. Now, certainly he would have suffered significant impairment, but I expect the government is pursuing a witness. And my expectation on my research is a witness will say life-saving procedures within the first 2 hours would have saved or could have saved John O'Keefe. And so if Miss Reed knew within the first 2 hours that she hit him and that medical procedures could have saved his life, then this is relevant material to show her knowledge that something dramatic had happened. And that's why I want the 30 days. Only phone calls with her mother and father. Nothing else am I interested in. The second part is the 24-hour period with William Reed. The 24-hour phone records will show Mr. Reed's phone calls throughout that evening or that morning. And it's important because Mr. Reed had an opportunity to speak publicly, and he did so on Fox 25, which is the subject of another motion. And when he speaks to Fox 25, he gives what I see as an implied admission that his daughter told him that she had hit something. I think there's more to that story that will be explored at trial. The time of the phone calls to Miss Reed are important. They're reflected in her phone records in the morning that she speaks to her father while she's still in the back of a police car before she's brought to the hospital. In that discussion with Fox 25, the quote is, "In your first discussions," my motion leaves off the yes in discussion, but it's in the first discussions, what did she tell you? Mr. Reed asserts that she tells him about this implied confession at the hospital, which is after the actual first conversation. And so it will be important to be able to confront Mr. Reed, if necessary, with his own phone records. He can denounce or deny his daughter's phone records. He doesn't have to accept them as true. Also, in that first 24-hour period, it is important for the government to establish that Mr. Reed and only Mr. Reed controlled the phone. In the absence of a stipulation, this is proof that may be necessary at trial if Mr. Reed takes the position that other people had access to his phone. That first conversation where she admits that she struck something, i.e. Mr. O'Keefe, is critical to the government's case. And so we cannot rely just on Ms. Reed's phone for a couple of reasons. Number one, phone records often show different communications. Sometimes calls or hang-ups don't register on a phone, and so they could be different. Secondly, I've learned that Ms. Reed's phone was sent to a taint team, and the Commonwealth does not and should not know what, if anything, was redacted from Ms. Reed's records. The idea of sending it to a taint team, I surmise, is that something was viewed that determined that it should go to a taint team, or perhaps the defense raised the issue. I don't have the benefit of the history. But what I do know is we cannot say that the records from Ms. Reed are a full accounting of her records, and so that Mr. Reed's records stand separately from Ms. Reed's records. Those are the two different types of records I am requesting from William Reed. I've been careful to make it limited. I'm not looking to see their physical phone. I'm not looking for a forensic download. After the first day of Mr. Reed's records, all I am looking for is call subscriber information and phone registers. I note the defense point of collateral information.
As I said earlier, guys, what are call logs going to prove? He's not even asking for the data. He's not asking for cell phone extractions. So what is he asking for? He's asking for call logs. For what? So that he can like guess what was going on in the calls? Like, what is the point? OMG, like, what is the point? Like, okay, so she calls her father, and maybe that phone call lasted 10 minutes. Maybe the other phone call lasted 20 minutes. Like, what is that going to reveal? It's not going to reveal the discussion. Again, a waste of time, a waste of state and taxpayer resources.
I don't even want to see it. I just want to see if there's communication between Ms. Reed and her parents, so that if we present that inference, it is a sound inference, it is a fair inference, and it is a solid inference.
It's not a solid inference, Brennan. It's not a solid inference. You receive the call logs, and then what? You can predict, you can assume what the discussions were about. That's not a solid inference. Just another prosecutor in this case who's completely full of shit.
That's my argument regarding the phone records of Mr. Reed.
All right, who's arguing this for the defense?
Thank you, Your Honor. Your Honor, the defense requests that the Commonwealth's Rule 17 motion seeking Ms. Reed's father's private cell phone information be denied. The Commonwealth is seeking 3 categories of information for Mr. Reed's cell phone: his private subscriber information, all call records, call detail records, SMS, MMS, and all data use records from January 29th and January 30th, 2022. And finally, all call detail records for an entire month-long period spanning December 30th, 2021 until January 30th, 2022. Your Honor, we are 3 years into this litigation, and the Commonwealth is now seeking to invade Mr. Reed's privacy under the guise that it's seeking communications between Mr. Reed and his daughter. But the Commonwealth already has a record of all of the communications between Mr. Reed and his daughter on January 29th, from not one, but two separate sources. The Commonwealth is in possession of Ms. Reed's cell phone. It's also in possession of Ms. Reed's Verizon records. The Commonwealth is asking this court to sanction this gross invasion of her father's privacy so that the Commonwealth can sift through Mr. Reed's electronic data for information that is already in the possession of the Commonwealth. Now, I know Mr. Brennan says, I'm not interested in seeing anything else. But the problem is, that's not what his motion says, right? He's asking for every single call, regardless of recipient, for a month-long period. William Reed has never been called by the Commonwealth to testify as a witness in this case.
So this is a new trial, right? So that doesn't prohibit the Commonwealth from calling him.
I understand, Your Honor.
Okay.
He wasn't present at 34 Fairview. He wasn't present at C.F. McCarthy's. And he wasn't present at the Waterfall on January 29th, 2022. And I would note that this court has repeatedly emphasized the importance of privacy concerns when it comes to an individual's cell phone, using that as a basis to deny the defendant's motions to obtain cell phone records from parties who were present that night. The Commonwealth, again, is already in possession of Ms. Reed's cell phone. That has been reviewed by both a special master as well as the court, and the court is well aware that the Commonwealth has a full copy of those communications. And what's important is that those call logs confirm that Ms. Reed did not make any calls to her father on January 29th until after she discovered Mr. O'Keefe lying incapacitated on Brian Albert's front lawn. And I've attached a copy of those records to our motion. It's quite clear. There was one call to her father on the morning of January 29th. That was at 6:32 a.m. The Commonwealth has a copy of those records. It's in their possession. And as this court knows, Lampron explicitly requires that any Rule 17 motion must be accompanied by an affidavit containing a factual showing that all four elements of Lampron were met. Here, the Commonwealth has failed to meet its burden to meet even a single prong of that four-part test. In regards...
Just two things I want to point out. There are quite a few people sitting behind Karen Reed's defense team, and a lot of them were at the Halloween party I went to just last month. Anyway, I met a lot of them, so it's like reminiscent. It's nice to see that a lot of them are there to support Karen Reed. But another note is that what Elizabeth Little is saying is that the Commonwealth actually is supposed to follow four rules for the motion they're seeking. They're supposed to follow four prerequisites before filing that motion, and according to Elizabeth Little, they did not meet even one prerequisite. So the Commonwealth filed this motion under a certain rule, but the Commonwealth didn't actually follow that rule when they filed this motion.
The burden that they have to establish that the records are evidentiary and relevant. The Commonwealth, in its affidavit, set forth no particularized facts whatsoever to suggest that relevant information will be found in Mr. Reed's Verizon records. The affidavit makes only vague reference to an interview Mr. Reed gave to Boston 25, but fails to explain why that interview suggests that relevant communications will be found on his phone records. And I would note, the Commonwealth's characterization of that interview is incorrect and incomplete. I submitted additional reporting from Boston 25, which is the news organization that published a portion of that interview. And it's quite clear that Mr. Reed goes on to state during that interview that what he's referring to when his daughter said, "I believe I hit something," was the Chevy Traverse, which the court knows. We have a video of her hitting a Chevy Traverse that morning. The Commonwealth is already in possession of Ms. Reed's communications from January 29th. Those were included.
And Karen Reed also told Carrie Roberts and Jennifer McCabe that she thinks she cracked her taillight. Okay? So yes, there was a point in that morning, during that morning, that Karen Reed was pretty sure she backed into another vehicle. And she was pretty sure she cracked her taillight. But we all know that taillight was intact until the authorities took it to the Sally port. And then suddenly the taillight was missing pieces.
In the Commonwealth's motion itself, and the Commonwealth has failed to explain why it believes additional relevant communications will be found in the call detail and text records. That was not included in the affidavit. The Commonwealth states they expect to substantively admit the phone records between Ms. Reed and her father to prove that the 6:32 a.m. call took place. But they can do that with the phone records that they already have. Just because they have records from Verizon, that doesn't establish who answered the phone. That's not something that they're going to get from Verizon. The Commonwealth is well aware of that fact because they have Ms. Reed's cell phone and her Verizon records, so they can confirm that there's only one call on the morning of January 29th. The Commonwealth has provided no factual basis whatsoever to suggest that there are relevant communications that will be found on January 30th, the day after this incident. And the Commonwealth also requests that Ms. Reed's phone records for the full month preceding January 29, 2022 is necessary to show that it would be unusual for Karen to have called her father. And the Commonwealth did a kind of funny thing, right? They suggested during their arguments that she called both parents in the middle of the night. That's not true. There was only one call to her father on January 29th, the morning of. It was at 6:32 a.m. So the frequency at which Ms. Reed called her father's cell phone in the middle of the night has no relevance whatsoever. As to the
Notice the energy change, too, coming from Elizabeth Little and comparing it to that of Prosecutor Brennan, right? Prosecutor Brennan is much like Adam Lally in that they both attempt to speak smoothly and confidently, but it's a facade, it's a front. Whereas when Elizabeth Little speaks, she's speaking with sincerity. She's speaking with the truth having her back. She is holding on to facts that the prosecution cannot argue. Like, since the beginning, the defense team has had the truth on their side. And they have had integrity. And they've pursued that truth. They have defended that truth. But notice how it's almost futile. Because it doesn't matter how much truth you have. It doesn't matter how much evidence you have. It doesn't matter that the federal government exonerated your client when you are ultimately up against a corrupt DA's office in a corrupt county of Massachusetts. Corruption seems to have more power than the truth. We've all bear witness to that during the Karen Reed case.
Second element of Lampron. Here, the Commonwealth's affidavit is facially deficient. It doesn't even reference this element or set forth any facts supporting that it's shown that the Commonwealth's records are not otherwise procurable reasonably in advance of trial. And the reason Mr. Brennan cannot in good faith make that statement under oath is because the Commonwealth is already in possession of these communications from two separate sources. Element 3 of Lampron was also not addressed in the Commonwealth's affidavit. It's facially deficient. The Commonwealth has failed to show that it cannot properly prepare for trial without the production of this evidence, and that the failure to obtain the evidence would unreasonably delay trial. Again, that's because the Commonwealth is already in possession of the evidence that they're requesting. Finally, the Commonwealth has also failed to show that this request is made in good faith and is not a fishing expedition. In its affidavit, the Commonwealth briefly addresses the fourth element of Lampron, but writes only, quote, "The Commonwealth's motion is not a fishing expedition, as it is evidence from the defendant's phone records that phone calls between defendant and Mr. Reed were made sometime after defendant struck the victim and before the victim was found." Your Honor, that statement is provably false. Ms. Reed's phone...
Can you guys believe it? Can you guys believe it? that the prosecution would waste everyone's time with this bullshit motion, and they are using lies to justify their motion. And I've said it before, and I'll say it again. If Judge Beverly Cannoni gives the prosecution what they're asking for, even though the prosecution used lies, provable lies to get what they're asking for, then Judge Beverly Cannoni needs to be thrown off the bench. But it's not going to happen. It's not going to happen. She, despite her bias and despite her corruption, which everyone witnessed during trial, Judge Beverly Cannoni is still in Norfolk County. She is still in the state of Massachusetts, and she is still overseeing other cases in the state of Massachusetts. And the state of Massachusetts has done nothing about it. The state of Massachusetts has done nothing about Judge Beverly Cannoni.
Records established conclusively that she did not call her father on January 29th until 6:32 a.m. after she found her boyfriend incapacitated on Brian Albert's front lawn. Therefore, the requested records should not be turned over to the Commonwealth. This is a broad request to review a month's worth of Mr. Reed's private cell phone information and all of his data usage information from January 29th and January 30th. This is a fishing expedition, plain and simple. The Commonwealth isn't asking for the records it already has. It doesn't need a third copy of them. What it's looking to do is sift through Mr. Reed's personal cell phone information on January 29th to see if it can find data usage information, location information, text messages with other individuals, and that is a completely inappropriate use of Rule 17. This unsupported request is overbroad and must be denied. Thank you.
All right, thank you. Did you want to respond in any way, Mr. Brennan, or move on?
Very briefly.
Okay.
In between the multiple accusations of bad faith, what the attorney says that is most telling is...
Did you guys see Aidan Kearney and his girlfriend?
They don't know who answered the phone. That's a harbinger to trial. The prosecution doesn't know who answered the phone when Karen Reed called her parents or her mother's phone at 1:43 a.m. No, the Commonwealth doesn't. And so, we have to prepare that when Mr. Reed takes the stand, we have phone records demonstrating all of his phone calls and that he had control of that phone, so there can't be a suggestion somebody else was handling the phone. Or, on the other hand, if the position is going to be that Janet Reed answered the phone, the father's phone, or that William Reed answered the mother's phone, then we'll call both witnesses at trial and we'll sort it out. But it is that very nature of suggesting confusion or uncertainty that the government is obligated to try to prevent at trial. And we're being diligent, we're being studious, and we're going to be prepared. And these records will help us do that. That is the exact point and reason why we need these records. Thank you.
All right, did you want to respond at all, Ms. Little?
Well, I think the Commonwealth actually brought up the issue of, it tried to basically say, I need the Verizon records because Karen's phone records don't establish that Mr. Reed answered the phone. But all I'm saying is that neither do the Verizon records. So there is no additional information the Commonwealth is going to obtain by digging through Mr. Reed's private cell phone information.
Okay. All right, so we sort of overlapped a little bit with Mrs. Reed, Janet Reed's records. Do you want to be heard further on that, Mr. Brennan?
No, I believe the court understands my argument unless the court has any questions for me.
I don't, but thank you. Ms. Little.
And why don't you have questions, Judge Bev? Why don't you have questions when Elizabeth Little clearly laid it out for you and said that the prosecution did not meet a single prerequisite for filing this motion under that rule, under Rule 17? Why don't you have questions, Judge Bev? You've had questions for the defense. You've asked the defense to clarify shit. I don't see you asking the prosecution to clarify anything.
Is there anything specific to Mrs. Reed that you want to address?
Yes, Your Honor. Again, I just emphasize that The affidavit in support of their request for Ms. Reed's phone records is plainly insufficient. They haven't addressed numerous elements of land prime. That alone is a basis to deny the request, and it's not permissive. It's mandatory that the court deny the request. Land prime is very clear. If you don't meet a factual showing in the affidavit in support of your Rule 17 motion, then the motion must be denied. 3 of the elements were not even addressed in that motion. So on that basis, we request that the court deny the motion.
Okay, thank you. All right, so we will move along now. Both of those are under advisement. We'll move along now to
the people behind Karen Reed's parents, Aiden Kearney, his girlfriend, and I believe that's Esty or Etsy, who's also a member of the Free Karen Reed community. I actually participated in a live stream with her. But anyway, there's a lot of people here, and a lot of whom I saw at the party, like I said. They all, as soon as Judge Bev said, and those are all under advisements, like, as soon as Judge Bev said that the prosecution's motion is under advisement and that the defense's motion to deny the prosecution's motion is also under advisement, everyone in the sitting behind Karen Reed's parents kind of rolled their eyes. They kind of like, they all kind of sighed like, oh yeah, like under advisement. We all know what that means.
paper number 405, Commonwealth's renewed motion for all audio recordings, notes, emails, text messages, voicemails, and the possession of Gretchen Voss and or Metro Corp. I do have an opposition that I received this morning in an affidavit from Robert Birch, attorney Robert Birch, who I think is present in court. So, Jim, did he file an appearance too?
He has previously filed.
And we'll use that in this case as well. All right, so Ms. Little, you did not intend to argue that, right?
No, Your Honor.
Okay, so Mr. Brennan, I'll hear you, and then Mr. Birch, I'll hear you.
And I guess I don't really see the point for Brennan. He's essentially Adam Lally 2.0, but far more annoying and far more, I don't know, just something missing. There's something not all there about him. Like, I kind of see Adam Lally as a fool who just does as he's told, but Brennan is something else. He's like a robot.
The Commonwealth has filed a motion to reconsider in part, and in addition, there was a request for information that was not requested before by the Commonwealth. Your Honor made a ruling in the past to turn over portions of the materials, and in that ruling, it invited the Commonwealth after review to renew or reconsider the motion or the extent of the motion. I've had an opportunity to listen to the hearing. I've had an opportunity.
I guess I only just now noticed that Paul O'Keefe is right there to the left of Brennan.
To review all of the pleadings relative to the Boston Magazine and Ms. Voss information.
I meant to the right of Brennan. It's my left, it's Brennan's right. So anyway, you can clearly see Paul O'Keefe. He's at the very last seat of that row, in front of those, I'm assuming they're police officers. They could just be security guards of the court.
And I've had the benefit of observing numerous other statements that have been made by Ms. Reed publicly. And I've been able to contrast and compare the statements made to Ms. Voss as well as the statements made to a number of other media organizations, including Dateline, 2020, Vanity Fair. And after a review of all those materials, it is clear that there is significant materials that were not turned over to the Commonwealth that are relevant material and substantive evidence in this case. In listening to the past hearing, the position of Boston Magazine was that almost everything was entirely on record. and that there were a few interchanges by the attorneys. Not only did I have an opportunity to read the Boston Magazine article and listen to the interviews, but I had them transcribed, have a copy for the court if the court pleases.
Yeah, that would be helpful.
And there were two different interviews that were turned over. One was represented at the last hearing, that it was 4 hours long. The Commonwealth received 3 hours and 19 minutes. It's missing, not a little bit, a significant portion of that hearing, 40 minutes. The second interview was represented in the audio recording of court that I listened to as a 2-hour interview. The Commonwealth received merely 19 minutes. So the majority of that interview was not provided. And so there wasn't just a few redactions. They were significant. In addition, which is notable, and you can glean this from the transcripts, is that there wasn't just a few interruptions. Mr. Yannetti is noted on the transcript 37 times, Attorney Little 33 times, and Attorney Jackson 33 times. And so there are significant interruptions and redactions in both recordings. These redactions in the recordings are important. One thing that stands out when you actually listen to the interviews and you look at the transcripts is that many times during the attorney's interruptions, there's a redaction, and then when the conversation resumes, there is a change, sometimes subtle, sometimes not so. There is a change in the statement by Ms. Reed. And so it is clear that there is an inference that in those redacted portions, there is conversation or consultation or discussion happening that changes the direction and sometimes the content of Ms. Reed's statements.
So because Karen Reed has paid for lawyers, and those lawyers were assisting Karen Reed during her interviews with these mega news networks, with these mainstream news media networks, because her lawyers were providing her with assistance, with legal assistance, as lawyers do, and because there were approximately 100 interruptions during these interviews, Karen Reed is being suspicious. That's what Brennan is implying. Because Karen Reed's lawyers were behaving like her lawyers, Karen Reed is being suspicious.
That bears directly on the credibility of the witness. Because be mindful, all of her statements are admissible. All of them. They're all substantive evidence. There's no hearsay. There's no limitation. They are statements of a defendant. They're material and relevant, and the Commonwealth is free to use any and all of them at their discretion. And so it's not only what she says in the interview, it is what is missing in the redactions. Now, certainly, there may be discussions in those redactions that involve her attorneys and Ms. Voss. But none of that is protected. None of that is protected. A defendant enjoys many privileges, but when an accused decides to cast aside their privileges, they don't get to add their own layer of protection. There's absolutely no basis in our jurisprudence for a defendant to be able to do that. They enjoy a Fifth Amendment privilege as they should. A defendant is presumed innocent. But when they cast it aside, it's at their own peril. They have an attorney-client privilege. But when they obviate the attorney-client privilege by speaking in front of a third party that's not part of the prosecution team, that privilege no longer exists. It dies. And there is no...
So Brennan is saying that there is no attorney-client privilege during these interviews that Karen Reed had with those magazines and those mainstream news networks, because as Karen Reed's attorneys were intervening and interrupting to tell Karen Reed what to say and what not to say, again, to defend their client against mainstream media and against the public, right? Because anything you say can be misinterpreted, right? Again, they're just doing their fucking job as her lawyers. But anyway, Brennan is saying that there is no lawyer or client privilege, confidentiality, because these interruptions occurred with Miss Moss, with a third party, in front of a third party. And I argue how much that third party actually heard what the lawyers said to their client, Karen Reed. You know, just because a third party was there doesn't mean that her lawyers were speaking loudly. Right? I don't see it. I can't see it. I can't see Elizabeth Little or David Yannetti or Alan Jackson saying out loud for the cameramen and the producers and the interviewer to hear, Karen, don't say that. Karen, come here. Don't say that because of this reason. Like, no, they would have been hush hush. They would have spoken with Karen Reed, probably whispering to her what statements are better for her to say to a mainstream news network, right? I'm just saying, Brennan is annoying as hell with his non-arguments.
Reporter privilege in Massachusetts. And so what has happened in this interview is that we have 3 attorneys, a defendant, and a reporter having a free reign of interview, and then later deciding what parts of the interview they want the public to hear, what parts of the interview they want the Commonwealth to have possession of. They don't have, respectfully, that choice or that power or that discretion. They can contract with each other, have their own side agreements and what they want about on and off the record, but it doesn't bind the Commonwealth. It never has, it never will. We don't agree to it. And so what we have is many instances and examples where those redacted portions are critical to understanding why the story at times changes after the redactions. And so I think of it this way. If Ms. Voss was called to testify by the Commonwealth at trial, and we have her on the stand, and I was to say to her, I've received your recordings and your redactions, and I've read your article, Ms. Voss. I want to ask you about the conversation after Ms. Reed talks about sipping drinks at the waterfall, and it's redacted. I want you to tell me what she said. There could be no objection for the defense that there's a private agreement. There could be no objection from the defense that somehow it's privileged. She would have to answer the question, this is what Karen Reed told me. So to suggest that pre-trial, somehow they can have this protection that doesn't exist in reality in the law, to protect statements that the defendant or their attorneys made that they don't want the Commonwealth to learn about is just wishful thinking. That's all it is. And, you know, I'm not oblivious to the fact that there are a number of statements that are made that are redacted to Ms. Voss where the defense attorneys are present in the room. There is no attorney-client privilege at that point. There's none. Arguably, all 3 of the attorneys are witnesses as well. Now, Commonwealth is not heavy-handed. The Commonwealth does not want to disrupt the defense team. The Commonwealth does not want to delay this trial. The Commonwealth does not want to put an attorney in an uncomfortable position. But they're all witnesses to a substantive statement, many of them admissions of guilt, contradictions, all of them, in the most respectful way to pursue those, the strongest way, the fairest way to pursue those, with moderation, is to get them from Emily Voss in the interview that exists. Now, in the pleadings, I received the response this morning. I didn't get to read the entire thing. I have no objection to it. But I did listen to the hearing. And it strikes me that the argument of the newspaper company was primarily based on 2 propositions. Number 1, Commonwealth versus Doe, promulgation. Those cases, when you read them, deal with confidential informants. Not confidential information or what someone wants to be confidential. It's not even confidential. She said it, she said it. There's a difference, and Your Honor pointed out in that hearing. Could you give me a case that talks about confidential information as it does confidential informants? And respectfully, there was no case to be produced, because there is none. The cases are dissimilar, because they deal with trying to get to a confidential source that may expose a source that may not be used at trial anyways, because it's based on hearsay or there's no factual basis for it. This is not a confidential informant. The defense chose a strategy, a very strategic strategy, to sell their story and disseminate to the public, potential jury pool, in a way they thought best fit their needs. And they've done this continually. And although an attorney cannot...
I might make a part 2. We will see. I get too triggered watching the prosecution make non-arguments. But I just want to say, like, that Brennan can come there today, can be there today, arguing what he's arguing, like, oh, the jury and the public, like, oh, all these interviews are going to influence the jury members, the future potential jury members for this case. Like, as if the mainstream media, as if Court TV and Canton Confidential didn't already taint Karen Reed with the narrative that she did this to John O'Keefe. What about that, Brennan? What about tainting the jury that way? This is like an attempt to gotcha, to get Karen Reed. You know, oh, you did that interview with that mainstream news network? We're gonna get you. Right? Like you think you can just go and tell your story to the world without consequences? We don't think so. We're the prosecution. This guys, Brennan has been lying since he opened up his mouth. He was lying since he filed the motion. This is all a lie. Again, Elizabeth Little, mic dropped. She went through it. Like, what phone call was made to Karen Reed's father at 1:30 a.m. on January 29, 2022? There was no phone call. It was after 6 a.m. After John O'Keefe was found. So, again, what is the point of this fucking motion? It is a fishing expedition. The defense team is absolutely correct. And again, as I said earlier, what does it matter if Brennan obtains the call logs, if the Commonwealth obtains the call logs, when they already have the call logs from Karen Reed's phone? It's abusive is what it is. They want to shake Karen Reed's parents. They want to disturb the peace in her family by treating her parents like criminals. By treating them like they have something to hide, so we need their cell phones. This prosecution is relentless at going after the wrong people. But notice how they don't go after the people who are actually responsible. Notice that, people. Notice how the prosecution prioritizes going after Karen Reed and her family, when Karen Reed wasn't even there when John O'Keefe suffered his injuries. But the prosecution will not go after the 10 or 20 people who were inside 34 Fairview. Again, I might make a part 2, but I get triggered and I can't help but yell when providing commentary about these douchebags, the prosecution. Every single one of them is a douchebag. Even McLaughlin, she's a douchebag too. Thank you for watching.